A summary of everything that is stated in this video may be found on the CoinMarketCap website. I would also like to remind you to give my channel a like and subscribe to it so that you can stay up to date on future XRP news, as well as other cryptocurrency news in general. Take a look at this now, shall we? A lawsuit filed by the SEC regarding XRP is being appealed. On the other hand, before we go any further, there is a brand new cryptocurrency airdrop that is currently taking place on Telegram and is set to start at any moment. I would ask that you make sure that you take part in this airdrop. Within the video's description is where you will find the link. Let's go with our video and make sure you don't miss out on this opportunity. In a submission that was made on October 17th, the United States Securities and Exchange Commission included a full appeal along with Form C. Whether or not the Securities and Exchange Commission (SEC) had missed the deadline was the subject of a great deal of conjecture and rumors on social media. The fact that this was not the case was brought to light in the news items that were published the day before. Now that the appeal has been properly lodged, let's find out what the implications of the appeal are for the lawsuit that Ripple is contesting against SC. It is probable that Ripple's victories will not be durable for a very long time. During the month of July 2023, judge analysts of Taurus made a verdict in which they stated that the sale of XR tokens by Ripple to individual investors does not constitute the sale of securities. The institutional sales, on the other hand, did constitute a significant amount of security in some way. Following the decision that you made earlier this year, Ripple Labs was subjected to a civil fine of $125 million on August 7th of this year. According to the Securities and Exchange Commission's motion, the court should impose a punishment of $2 billion on the cryptocurrency corporation and take all XRP sales action in accordance with securities legislation. We regret to inform you that this did not go according to plan, and Judge Torres did not accept the offer. It was a severe setback for the Securities and Exchange Commission (SEC). The move that was taken by the Securities and Exchange Commission at the very last minute. Before the deadline, the Commission had submitted its notice of appeal, and they have now done the same thing with the submission of Form CU. In the past, they had done this. It is not possible to cast doubt on the retail sales of XRP due to the attraction of the cryptocurrency. At the moment, the primary focus of their attention is on the personal sales done by Ripple workers as well as the offers and sales that are made through digital platforms by Ripple. The Securities and Exchange Commission is of the opinion that these various areas should continue to be considered violations of laws pertaining to securities. The conclusion reached by the court that the distribution of XRP for non-cash remuneration did not break any laws is another aspect of the case that is being appealed. An exciting facet of the appeal that will be taken into consideration is the de novo review, which indicates that the appellate court will investigate the legal difficulties from the very beginning of the process. As a consequence of this, it is now feasible to arrive at a fresh perception of the securities laws that are under consideration. The struggle that Ripple is currently engaged in is not yet over, at least not for the time being. However, the retail victory has not yet been achieved. The answer to the question is provided by Ripple. As stated by Stuart Alderety, the chief legal officer at Ripple, in a post that he made on the social media platform X, it is fairly obvious that XRP is not as secure as he claims it to be. Furthermore, he suggested that the community continue to keep a close check on the case throughout the upcoming week, as Ripple is set to file its Form C. He wanted to make sure that everyone was aware of the situation. In light of the most recent action taken by the SEC, Ripple's route is now accompanied by an increased degree of ambiguity. It is because there is a great deal of uncertainty over the deadlines for filing with the SEC. The community of cryptocurrency enthusiasts is making sure to keep a close eye on the issue. Was it impossible for the Securities and Exchange Commission to reach the deadline that was set by the law? There are those who are convinced that they did, while others are not really confident. The Securities and Exchange Commission (SEC) and Ripple are likely to proceed with additional legal battles in the near future. The outcome of these battles may have an effect on the manner in which cryptocurrencies are regulated in the future. The United States Securities and Exchange Commission has filed an appeal, with the exception of the case that was brought by Ripple Labs. This is despite the fact that Ripple has achieved some success through the selling of XRP in the continuing legal battle that the Securities and Exchange Commission (SEC) is fighting against Ripple Labs. Another stage of the conflict has been reached with the submission of a civil appeal pre-argument statement by the Securities and Exchange Commission (SEC). Ripple's programmatic sales of XRP on secondary exchanges, which were previously judged to not constitute security sales, are the focus of the appeal, which questions the finding that the court made regarding these sales. The appeal is being filed in order to contest the conclusion that the original court reached. As a consequence of the ruling, Ripple was able to gain a significant victory, which had the effect of elevating the value of XRP and fostering hope among members of the cryptocurrency community. The Securities and Exchange Commission is likely to re-examine this decision, which might have adverse effects for Ripple and its executives, Brad Garlinghouse and Chris Larson, whose suspected involvement in illegal securities transactions is still being contested. Despite this, the ruling is likely to be reconsidered. Form C, which contains the issues that the State Election Commission of India intends to appeal in the Ripple case, has been submitted by the Commission. The cryptocurrency sector is currently going through a monumental event as a result of this litigation, which is testing the legal constraints of how digital assets are defined. This is one of the concerns that has been brought up, and it is one of the issues that has been brought up. And the cryptocurrency known as XRP has been defended by Ripple as not being a security. The company has emphasized the usefulness of XRP as a bridge currency for international financial transactions. In the initial verdict, the court reached a decision that was in agreement with Ripple's viewpoint and concluded that XRP that was sold on exchanges did not meet the criteria for securities. This occurred due to the fact that purchasers did not hold the expectation of making a profit from Ripple's efforts. In its most recent appeal, the Securities and Exchange Commission (SEC) has taken efforts to reverse this ruling, which may have implications not only for Ripple but also for the entire cryptocurrency industry as a whole. The outcome of this appeal could potentially have significant ramifications for the regulation of cryptocurrencies that will be implemented in the near future. Should the Securities and Exchange Commission (SEC) achieve its goals, it may lead to a more strict oversight of transactions that involve digital assets. Ripple's ongoing defensive defense, on the other hand, has the potential to set a precedent that will be followed in the future regarding the legal treatment of cryptocurrencies. At this point in time, the cryptocurrency world is waiting to see whether this appeal would further strengthen Ripple's victory or whether it will redefine the environment as the case continues to evolve. Within the context of the ongoing Ripple case, a notable legal expert has shared some comments on the anticipated appeal that will be filed by the Securities and Exchange Commission. Has described the key areas that the Securities and Exchange Commission is likely to examine. It is the decisions that the Supreme Court has made involving programmatic sales and other distributions of Ripple's native cryptocurrency, XRP, that are the primary focus of the Securities and Exchange Commission (SEC). The Securities and Exchange Commission will file an appeal against the decision to discourage. Ripple makes the observation that the Securities and Exchange Commission Secretary will almost probably challenge the finding that Judge Annalisa Torres made regarding the discouragement of earnings. In the beginning, the Securities and Exchange Commission attempted to levy a staggering $2 billion in fines against Ripple. Nevertheless, the judge made a significant decrease to this amount, lowering it down to $125 million from its previous level. The Securities and Exchange Commission is expected to argue that this punishment is insufficient in view of the extensive list of offenses that it has accused Ripple of committing. This is something that is expected to happen. The chief court officer for Ripple, Stuart Alderode, has expressed his confidence that the cryptocurrency will emerge victorious in the subsequent stage of the court conflict. This is something that has been said by Alderode. By making this statement, he is expressing his anticipation that the Federal Court of Appeals will, at some point in the future, put a stop to Gensler's mistaken attempt to target the Bitcoin business. It was made quite clear by Alderode that Ripple is prepared to provide a response to the appeal that will be submitted by the federal government for consideration. It is important to pay attention to both penalty sales and programmatic sales. The Securities and Exchange Commission is likely to oppose not only the amount of the penalty, but also the conclusions reached by the court about Ripple's programmatic sales of XRP and other disbursements, as stated by Ripple. This is because the SEC is likely to contest not only the overall amount of the punishment. It should be noted that the material that has been supplied is not intended to serve as business advice. In the event that any investments are made on the basis of the information that is provided on this page, there is no responsibility for those investments. Prior to making any choice on investments, we strongly recommend performing independent research and talking with a professional who is educated in the field.